Hello. Today I'm reading from For the Record, a documentary history of America, edited by David Shee and Holly Mayer. And I'm reading a passage from Brown versus the Board of Education of Topeka, 1954. After trying for almost half a century, the National Association for the Advancement of Colored People finally succeeded in getting the Supreme Court to review the separate but equal principle articulated in Plessy versus Ferguson case of 1896. In the mid-50s, the vast majority of public schools, especially in the South, were racially separate but far from equal in resources or facilities. In the Brown case, however, the court did not stress this fact. Instead, it advanced a different line of reasoning that ultimately invalidated racially based school segregation. While the decision did not transform school systems overnight, the unanimous court provided the foundation for great advances over the next 10 years. Chief Justice Warren. These cases come to us from the states of Kansas, South Carolina, Virginia, and Delaware. They are premised on different facts and different local conditions, but a common legal question justifies their consideration together in this consolidated opinion. In each of the cases, minors of the Negro race, through their legal representatives, seek the aid of the courts to obtain admission to the public schools of their community on a non-segregated basis. In each instance, they have been denied admission to schools attended by white children under laws requiring or permitting segregation according to race. This segregation was allegedly to deprive the plaintiffs of equal protection of the laws under the 14th Amendment. In each of the cases other than the Delaware case, a three-judge federal district court denied relief to the plaintiff on the so-called separate but equal doctrine announced by this court in Plessy versus Ferguson, 1896. Under that doctrine, equality of treatment is accorded when the races are provided substantially equal facilities, even though these facilities be separate. The plaintiffs contend that segregated public schools are not equal and cannot be made equal, and that hence they are deprived of the equal protection of the laws. Because of the obvious importance of the question presented, the court took jurisdiction. Re-argument was largely devoted to the circumstances surrounding the adoption of the 14th Amendment in 1868. It covered exhaustively consideration of the amendment in Congress, ratified by the states, then existing practices in racial segregation, and the views of proponents and opponents of the amendment. This discussion and our own investigation convince us that, although these sources cast some light, it is not enough to resolve the problem with which we are faced. At best, they are inconclusive. The most avid proponents of the post-Civil War amendment undoubtedly intended them to remove all legal distinctions among all persons born or naturalized in the United States. Their opponents just as certainly are antagonistic to both the letter and the spirit of the amendments and wish them to have the most limited effect. What others in Congress and the state legislature had in mind cannot be determined with any degree of certainty. An additional reason for the inconclusive nature of the amendment's history with respect to segregated schools is the status of public education at that time. In the South, the movement toward free common schools supported by general taxation had not yet taken hold. Education of white children was largely in the hand of private groups. Education of Negroes was almost non-existent, and practically all of the races were illiterate. In fact, any education of Negroes was forbidden by law in some states. Today, in contrast, many Negroes have achieved outstanding success in the arts and sciences as well as the business and professional world. It is true that public education had already advanced further in the North, but the effect of the amendment in the northern states was generally ignored in the congressional debates. Even in the North, the conditions of public education did not approximate those existing today. The curriculum was usually rudimentary. Ungraded schools were common in rural areas. The school term was but 3 months a year in many states, and compulsory school attendance was virtually unknown. As a consequence, it is not surprising that there should be so little in the history of the 14th Amendment relating to this intended effect on public education. In the first cases in this court, construing the 14th Amendment, decided shortly after adoption, the court interpreted as proscribing all state-imposed discriminations against the Negro race. Doctrine of separate but equal did not make its appearance in this court until 1896 in the case of Plessy v. Ferguson, involving not education but transportation. In approaching this problem, we cannot turn the clock back to 1868 when the amendment was adopted, or even to 1896 when Plessy v. Ferguson was written. We must consider public education in light of its full development and its present place in American life throughout the nation. Only in this way can it be determined if segregation in public schools deprives those plaintiffs of equal protection of the laws. Today, education is perhaps the most important function of state and local governments. Compulsory school attendance laws and the great expenditures for education both demonstrate our recognition of the importance of education to our democratic society. It is required in the performance of our most basic public responsibilities, even service in the armed forces. It is the very foundation of good citizenship. Today, it is a principal instrument in awakening the child to cultural values, in preparing him for later professional training, and in helping him to adjust normally to his environment. In these days, it is doubtful that any child may be reasonably expected to succeed in life if he is denied the opportunity of an education. Such an opportunity, where the state has undertaken to provide it, is a right which must be made available to all on equal terms. We come then to the question presented: does segregation of children in public schools solely on basis of race, even though the physical facilities and other tangible factors may be equal, deprive the children of the minority group of equal educational opportunities? We believe that it does. In Swaite versus Painter, in finding that a segregated law school for Negroes could not provide them equal educational opportunities, this court relied in large part on those qualities which are incapable of objective measurement, but which make for greatness in a law school. In Loren versus Oklahoma State Regents, the court, in requiring that a Negro admitted to a white graduate school be treated like all other students, again resorted to intangible considerations: his ability to study, to engage in discussions, and exchange views with other students, and in general, to learn his profession. Such considerations apply with added force to children in grade and high schools. To separate them from others of similar age and qualifications solely because of their race generates a feeling of inferiority as to their status in the community that may affect their hearts and minds in a way unlikely ever to be undone. The effect of this separation on their educational opportunities was well stated by a finding in the Kansas State case by a court which nevertheless felt compelled to rule against the Negro plaintiffs. Quote, segregation of white and colored children in public schools has a detrimental effect upon the colored children. The impact is greater when it has the sanction of the law. But the policy of separating the races is usually interpreted as denoting the inferiority of the Negro group. A sense of inferiority affects the motivation of a child to learn. Segregation with the sanction of law, therefore, has a tendency to retard the educational and mental development of Negro children and deprive them of some of the benefits they would receive in a racially integrated school system." End quote. Whatever may have been the extent of psychological knowledge at the time of Plessy versus Ferguson, this finding is amply supported by modern authority. Any language in Plessy versus Ferguson contrary to this finding is rejected. We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal. Therefore, we hold that the plaintiffs and others similarly situated for whom the actions have been brought are, by reason of the segregation complained of, deprived of the equal protection of the laws guaranteed by the Fourth Amendment.